to still even...
Let's go back to the Nyeri High Court, where Justice Jarasinga is making a ruling on whether, Peter Mugure is expected to be released on bail or not.
Whenever the court is called upon to consider this question, the right approach is not to ask whether bail should be granted, but whether there are good reasons to refuse it. This explains why I believe the practice of applying for bail or bond is outdated and ought to have been buried with the 1964 Constitution. Embedded in Article 49(1)H is the tension between the rights of the individual and the wider public interest. The Constitution seeks to strike a balance between the two. It is in that spirit that the decision to grant or reject bail should not only be made, but must be seen to be made. If, for instance, bail is granted, oblivious of this balance, there is the danger that the public will lose confidence in the administration of justice and possibly pave way for such vices as anarchy. And so, the accused need not be granted bail if the court is satisfied that there are substantial grounds for believing that if released on bail or bond, the accused will either abscond or commit another offense or interfere with the witnesses or otherwise obstruct the course of justice. Thus, even if, as counsel for the accused are submitted, the accused is prepared to comply with whatever conditions the court can impose, in order to secure his freedom, bail or bond will still be refused if there are substantial grounds for believing that the risks of absconding, committing another offense, interfering with witnesses, or otherwise obstructing the course of justice still subsist. The converse is true. If the conditions imposed will limit or reduce these risks, then bail should be granted. The severity of the sentence risked is a matter to be taken into account, but the risk of absconding on account of severity of the potential sentence has to be assessed in the light of other relevant factors. Now, simply put, the severity of the sentence will be considered not in isolation, but among other relevant factors. Again, the seriousness of the offense is obviously a consideration to be weighed in the balance and not by itself a ground for refusing bail. For it is not the intention of the Constitution that once a person is charged with what is acknowledged as a serious offense, he should automatically be refused bail. Bearing this in mind, it is an irrefutable fact that it is almost natural that a person charged with a serious offense, facing a severe penalty if convicted, may well have a powerful incentive to abscond or interfere with witnesses likely to give evidence against him, where there are reasonable grounds to infer that the grant of bail may lead to such a result, which cannot be effectively eliminated by the imposition of appropriate conditions. They will afford good grounds for refusing bail. But as noted, they do not of themselves without more. They do not do so of themselves without more. They are factors relevant to the judgment whether in all circumstances it is necessary to deprive the applicant of his liberty. Whether or not that the conclusion reached, clear and explicit reasons should be given. And in this, I've referred to the judgment of the Supreme Court of England, of the Privy Council, of the United Kingdom, in Hanam versus the State of Mauritius. In considering such relevant factors as the gravity of the offense or the severity of the sentence, there is always the looming danger of the parties delving deep into the evidence, whose strength can only be tested during and after the trial. The court must, of course, guard against such a danger and refuse to be swayed into an elaborate or detailed analysis or examination of the evidence. The burden on the state is to satisfy the court that it is a prima facie case for refusal of bail. It need not prove beyond reasonable doubt that the case against the accused is grave, or that there is overwhelming evidence against him, or otherwise there are grounds against the grant of bail. Any of these things will be tested at the trial, where the appropriate test of proof beyond reasonable doubt will be applied. It is for this very reason that this test cannot be held as the threshold in pre-trial proceedings such as the present one. It is apparent that in the present case, the court has been given a glimpse of the evidence that the state will be mounting in the prosecution of its case against the accused. For reasons I've given, I'm conscious to treat this evidence with abundant caution. At the risk of repeating myself, I reiterate that this evidence has not been tested and proved to meet the necessary threshold of proof. For the same reason, the court need not attempt to make a detailed evaluation of the evidence, though its nature may be a relevant consideration. Still on the accused case, it is not in dispute that he faces 3 counts of murder. There is no dispute. And as a matter of fact, his own counsel admitted as much, that the charges are grave. The accused faces a potential death sentence if he was to be convicted on any of these 3 counts. Thus, the gravity of the charges and the severity of the sentence that the accused is exposed to cannot be underestimated or, for our present purposes, ignored. Of importance to note is the allegation against the accused that is likely to interfere with witnesses. This allegation was first raised in Corporal Mwaniki's affidavit of 19th December 2019. At that time, the allegation was merely based on the influence that the accused is perceived to hold thanks to his position in the army. Subsequently, and in particular, in Corporal Mwaniki's further affidavit of 21st January 2010, it came to light that Mwaniki's fears may not be far-fetched after all, because it emerged, if that affidavit is anything to go by, tangible attempts have been made not only to interfere with the witnesses, but also to obstruct the course of justice. I come to this conclusion because the allegations that the accused sister visited Collins Pamba in prison with instructions to recant his statement to the police have not been refuted. Neither the accused nor his sister swore any affidavit to controvert these factual allegations. In the absence of any sort of response from either the accused himself or his sister, it is reasonable for this court to proceed on the assumption that the depositions in Mr. Mwaniki's affidavit are true. And with this sort of evidence, the state has demonstrated to my satisfaction that having made attempts to interfere with witnesses and obstruct the course of justice while in custody, the accused is bound to achieve much more in that direction if he was to be granted bail or released on bond. In short, considering the accused's conduct, I cannot think of any conditions that this honorable court can possibly mete out to limit or reduce the risk of the accused committing another offense, interfering with witnesses, or otherwise obstructing the course of justice if he is released on bond. The accused's untoward conduct would be sufficient by itself to deny him bail. However, it is worth noting that this conduct is not considered in isolation. It is only one among other factors to which reference has already been made. In the ultimate, the safer option is to detain the accused rather than set him at large pending his trial. If I may borrow the language of the Constitution, I am satisfied that the state has presented compelling reasons why the accused should not be released on bail or bond pending his trial. Bail or bond is therefore refused. So you can take a date for the hearing of the case.
There you have it. Peter Mugure, the former KDF officer, will be spending his time in prison until the hearing of his case begins. Justice Jairus Ngaah has refused to, give Peter Mugure bail. His bail application has been denied. Justice Jairus Ngaah says that the evidence produced by the prosecution team that he has been trying to interfere with witnesses and statements that have been written by witnesses while in prison is something that has been proven by the prosecution team, hence the reason as to why he's made a decision not to grant Peter Mugure bail. Remember, Peter Mugure has been accused of killing his estranged wife, Joyce Siombua, and his two children, the daughter and the son. Our developing story right there. We will be getting more details from our reporter, Ibrahim Karanja, who's already in the courtroom. But the latest information we're getting from the Nyeri High Court, inside the courtroom, it is that Justice Jairus Ngaah has refused to give Peter Mugure give Peter Mugure bail. He says that the evidence produced by the prosecution team as to the reason as to why he should not be given bail is satisfactory, and that he needs to remain in prison. So the hearing of the case is what now the Justice Jairus Ngaah and the prosecution team, including the defense team,